Hi, everyone.
Hello.
Welcome to Winning Wednesday.
Winning Wednesday brought to you by Adair Thurston.
My name is Brandon Cott.
And I am Gabriela Vega. We are so glad to be here today with you. Got some messed up hair going on back there. Good Lord.
Oh, it's just Winning Wednesday. It's
Winning
not
Wednesday.
serious.
So we had scheduled for today child support as the topic of discussion. Unfortunately, our attorney that was scheduled to be here was not able to be here today. Sorry. Lawyering trumps fun stuff on Facebook.
True. That's also unfortunate.
That is very unfortunate. But nonetheless, Brandon and I still thought it was really important to talk a little bit with all of you. And we thought that we would discuss some of the information that Brandon and I can share with you. And that's some law basics in terms of how to get a case started, how to meet with a lawyer, what happens when you're going to court, and some hot tips and hints for you to be able, at the end, to be able to work well with the lawyers that you end up hiring in the future. So,
and it's nice to circle back too, because we did kind of start off with a lot of substantive material about our areas of practice. So now
very
we can
heavy
kind of
subject matter stuff,
circle
yes.
back and start talking about procedure, and in some respects how to make you feel more comfortable with it, so that those feelings of anxiety and dread that you get when you're like, oh, I've got to go to court.
Absolutely.
Maybe we can kind of take those and dampen them down a little bit.
Absolutely. So let's get started with discussing some basics about courtroom procedure, and we're going and in focusing on that, we're going to have Brandon take the lead, and so we're going to talk a little bit about what Brandon does as a criminal defense lawyer. Brandon, normally your clients are not the ones that initiate the action. It's prosecutors, it's the state, it's a government body initiating the action, correct?
Right. So in a criminal case, in my world, people come into my office usually in one of two ways, or three really. Number one, they've been arrested, then they've posted bond, and now they have a court date. When you get arrested and then you post a bond, you get a court date for your first appearance. There's another one called a notice to appear, or you can also have an arrest warrant, and that's basically where the state has compiled evidence against you, and now they are proceeding forward with formal charging. So, that can result in an arrest, right? It's an arrest warrant. You get arrested on the warrant, you post a bond, you get a court date, right? Okay. So the theme here is you get a court date, right? There's also summons. The notice to appear is kind of the watered down version of the warrant.
Or even a summons, right?
Right. And those are going to say appear on this day at this time. And if you don't, then there will be consequences, right? Okay. So it's just really a level of severity, but we get invited into court nonetheless. And so now we have what's called our first appearance date. But those are the ways that we get our first court date in criminal world.
Okay. And so normally the repercussions when, like Brandon said, when you don't respond to those notices to appear in court is that further consequences happen. And those consequences can then even impact the final outcome of a case because it may hamper, I'm assuming, like negotiations.
Absolutely.
For you, right?
Yeah.
So when somebody gets a notice, usually they're about 5 to 20 days out. Would you say, is that an accurate statement or no?
I would say sometimes even longer, and maybe even more traditionally about 30 days out.
Okay.
And so, you usually have time to ask off of work if you are getting assigned a court date, right? If you get arrested and you have to bond out, yeah, right. that's and especially if you have to be presented to a judge in order to get your bond, right? So we might be in jail for potentially up to 48 hours, right? Okay. But yes, after that process, usually we'll have about 30 days.
Okay. And so within 30 days, I know the answer to this. I'm sure other people would like to know the answer to this. Is our firm able to schedule someone to see a criminal defense lawyer for the first time and hopefully be there with them by that first appearance, that first hearing date?
Yes. That is usually my goal. Anytime that I get involved in a criminal case, I always tell my clients that I don't want them to appear anywhere without me. Part of the benefit of hiring an attorney is you have the comfort of somebody there to speak for you. Yes. Not everybody is comfortable speaking to crowds of people, and especially not in an environment where it can sometimes get a little bit contentious.
Absolutely.
And so that's part of the reason why I'm there. And so I really do not like my clients ever being in court without me, number one. So that's part of, having an attorney there at that first appearance, meeting with somebody. That's always my goal. Now, we don't always hit that goal, We're worried about coming up with money. Sometimes we get anxiety and we just shut down.
Don't call an attorney
we just think if we ignore this, if we ignore this, it's going to go away. Let me be the first and most beneficial people to tell you, you are wrong. It will not go away. So to a certain extent, we just need to get involved and be an active participant in our own rescue, right?
Absolutely.
So reach out to an attorney, discuss with them, and sometimes there can be certain kinds of cases where you might be able to handle it on your own. Let an attorney be the person to tell you that that's a safe route. Don't just assume that you're going to be able to do this, because I always tell people that 90% of my job is negotiations, and the sad fact is you just lack the negotiating power that an attorney has.
Absolutely. Absolutely.
So.
And so I agree. Those are really important things to know. A quick question, an excellent question that came up through Facebook.
Hi, Stacy.
Thank you, Stacy Kim, for sharing a question with us. Can you speak about retainers, or did you already speak about retainers? We have not spoken about retainers, Stacy. Great question. Thank you so much. Well, in our firm, our policy is that a lot of times, at least for criminal cases, Brandon, correct me if I'm wrong.
Right.
A lot of our criminal cases are handled through a flat fee, and you guys are willing to give people some payment plan options?
Right. Yeah. And so to answer the question, the retainer is something that's maybe more prevalent in a civil kind of aspect, where you have a company and you're a certain kind of company that's prone to a lot of litigation, right? In that respect, it would help and be a benefit to you to have a retainer attorney on constant call, right? Mm-hmm. For me, people do not get in trouble so often that they should have me on retainer.
A criminal defense.
Correct. That's more of a case-by-case basis. You certainly could have a criminal defense attorney on retainer if you wished.
Maybe if you're a mom of 4 boys.
right. So I can imagine where I have had situations where I have felt like I have been on retainer for certain clients, because we've just been in the process and we get tangled up, and a lot of times it speaks to that case where we've ignored something, right? Then we get something else, and then we get a warrant, and then
Absolutely.
And so then you kind of find yourself sorting through the weeds,
right.
And in that respect, definitely get an attorney, because do not sort the weeds by yourself.
And I guess I should have clarified, because retainer is a lot of times can mean advanced money to be used in the event that litigation is needed. In cases, for example, like with Brandon, we already know litigation is needed, and so retainer can be used to mean interchangeably advancing the fees, the cost of the case involved. Yeah. In cases, and Stacy, thank you for the follow-up question, should people just have an attorney on retainer? That's a great question. I think that question is dependent on the type of law that you're needing the attorney for. Like Brandon said, as a criminal defense attorney, people make mistakes. That's human life. Humans make errors. Normally, most people do not keep making the same mistakes. On the other hand,
some people do.
On the other hand, if you do tend to have a history of making mistakes, or if you're going through something like drug issues, addiction issues, I imagine that maybe having an attorney on retainer can be valuable. Normally, the types of people that would have attorneys on retainer would be like Brandon said, corporations, businesses. I have seen individuals with divorce.
Yeah.
Maintaining.
I can imagine.
Yeah,
that.
maintaining their attorney and keeping a retainer there, so that the minute that a situation arises, that the attorney is willing to drop everything to start on their case as well.
And actually, that does bring me to an important circle back point. Another way, when we've got this arrest warrant kind of thing, how we get invited into court. Another way is if we have like police questioning. Now, this wouldn't be like a retainer, so to speak, but for instance, if somebody was going to the police wanted to talk to you, right, about a crime that they were investigating, that might be an instance where you would retain a criminal defense attorney prior to charges ever being filed, because you need representation during like police questioning. And number one, we're probably not gonna do it. that's probably the advice. But that's cheap.
No, absolutely. So that is a good that is a good point. You can There's a variety of reasons. So in talking about court processes, we discussed people hire you, have a preliminary hearing first appearance.
Right.
First appearance. So words that I've heard associated with criminal defense cases, and then I want you to break them down for each firm. Okay?
Absolutely.
First appearance, preliminary hearing. Can you talk a little bit about in driver's license hearings? Talk about those specific things and how they also apply to how you help people in your cases in criminal defense world.
Perfect. Okay. So first appearance, that can also be synonymous with, or also called an arraignment. Mm-hmm. In felony cases, more often you'll hear it referred to as an arraignment, because that can have some special consequences for us in the felony world, as well as in the misdemeanor and traffic world. The first appearance is where we're going to go into court and we're going to say not guilty or no contest, right? Okay. Anytime somebody wants to hire an attorney in criminal world in order to look into a case, to figure something out, to see if there's something there, we're going to go into court, we're going to plead not guilty. Some courts don't even require clients to be there. I always tell my clients, if they don't have to be there, not to. It doesn't make any sense for them to be there to listen to me talk for 15 seconds, right?
Absolutely.
It's pretty simple. And that basically keeps the process moving forward, right? So between the arraignment and potentially a preliminary hearing or some other status hearing, we're trying to get discovery, we're trying to get evidence, videos, police reports, so that way...
And all of these things, police reports, videos, fall under that umbrella of discovery.
Right.
That's a legal term of art.
Right.
So.
And that's stuff that we're being sent by the prosecuting body most times in order to determine if there are strengths to our case, weaknesses to our case, so that we can then advise our clients, right?
Absolutely.
Then after that, I usually try to meet with my client, go over everything, see what our best avenues of attack are, what we should do. And then in a felony case, we would have either a preliminary hearing, or in a misdemeanor case, we would be setting it for some kind of diversion conference, trial, motion to suppress, right?
Okay.
Motions hearing. Preliminary hearing is like a baby trial. In a felony case, the state has to produce enough evidence to show that there's probable cause that a felony was committed and that you were the person who committed it, right? Very low standard, probable cause, much lower than beyond a reasonable doubt when we're in actual criminal trial, right? And that's kind of, preliminary hearing is actually, fun fact, a vestige of the old system where you used to have a right to a speedy public trial, right?
Oh, okay.
Back in colonial times, people would disappear, they would be arrested, not given a bail, and they would basically be dealt with in that way. We wouldn't have a trial. So the preliminary hearing was actually put into place so that way the state was required to show that they actually had evidence that you committed a crime before they continued holding you prior to trial.
Oh, okay.
So kind of a historical vestige, but the preliminary hearing still has meaning today. A lot of times, we're getting plea negotiations done around that time. So that's another thing to look for in your case. So long description. So I covered first appearance, preliminary hearing, and we wanted, what else?
I first wanted you to cover all the steps of a trial, leading up to a case, possible trial or dismissal or whatever, right?
Right.
But then I also asked you to discuss driver's license hearings and
yes.
how that can also be included within the work that you do.
Yes. So specifically with DUI cases, a lot of times those are going to be misdemeanor charges. Third offense and above DUI, gonna be a felony, right? So we would even have that preliminary hearing mixed in with that one.
Absolutely.
So in terms of the administrative case on a DUI, that functions wholly and separately of the criminal case that's going on against you. It's an administrative hearing. And as an administrative hearing, the burden is on us to show that the other side did something wrong in terms of testing, in terms of evidence that they had gathered.
Procedure.
Right,
Okay.
very. Almost all of the issues that you can cover there are going to be procedurally based issues.
Okay.
And the burden's on us, right? So it's different, it's a little more challenging, and we have to request it. So that's different than the criminal world. You know, in the criminal world, we get invited into court. On the administrative side, you have to send in your invitation, and then they send you back an invitation with the party date. It's very secret. And then you get to go to the party, and then sometimes you have to go to another party after that one. So, but the fact is, it's kind of a journey through the system can be confusing on that side. And so if at any point in a DUI case you think that there is something wrong with your standard field sobriety testing or something, procedure wasn't followed, most of the time my clients don't even think of the issues that I discovered because they're very procedurally based, right? You have to know the procedure.
You have to know what the procedure is, to know what the law is on that, to know whether it was violated or not.
Right. And as a result of that, I almost always caution people to have somebody take a second look at it, measure twice, cut once, so to speak.
Absolutely.
So I hope that answers your question. I'm very long-winded off the cuff, everyone. So this is not Gabriella's fault.
That's okay. Everybody forgives me for you. No, I'm kidding.
That's usually what has to happen anyway.
So from a civil perspective, Brandon,
right.
We do things a little bit different, right? Mm-hmm. In, for example, civil cases like divorce cases, like family law cases, you can be either the person that does the invitation, here's an invitation to our divorce, or gets the invitation, right?
Right.
And so the important factor in this, and I know it is with you, but it's different in the civil world because in your case, missing the deadlines that are posed mean you may go back to jail. Right. In ours, in like civil world and divorce cases and in non-criminal cases, it doesn't necessarily mean that you go to jail, but worse, right? You can lose a lot of proprietary interest as a result of it. Right. So for example, if you are invited to a divorce and you do not participate in the divorce, the court can divide your property, split up your house, your property inside, your baseball card collection, whatever. If you did not respond to them, then you have told the court that you are choosing not to be involved in the process. And so though it's not jail, it can be just as detrimental because you can lose a lot of financial interest as a result of a divorce process.
True.
Usually at least for Kansas, we are Kansas lawyers, so all the advice that we give is Kansas specific.
Happy birthday, Kansas.
Oh, by the way,
happy
birthday, Kansas. We love you.
Yes. Shout out to my girl or boy, whichever. Kansas is whatever it wants to be. So, sorry about the interruption.
No,
it's
okay.
happy birthday stuff.
Yes, it's happy birthday, Kansas stuff. But as we said, all advice, all conversations that we give, we don't give legal advice on this video log, but we do share information as it pertains to Kansas law or if it pertains to immigration, federal law.
Yeah.
But nonetheless, so in Kansas, if you are invited to a divorce and you live in Kansas, you have 20 days to start responding and start getting involved. And within a very short time frame, if you don't get involved, by the 61st day after the divorce was filed, your the other party in the divorce can start getting divorced and start wrapping things up. So you really not responding at all gives them the ability to fast track how they divide your stuff. So very important. From an immigration perspective, there's two types of entry, alike with criminal court. If you are picked up by police and turned over to ICE, you will get what's called a notice to appear, NTA, we also call it, and we're invited to a deportation party. You are placed in deportation or removal proceedings, and that is one of the methods in immigration. The other method is that you initiate the party, and you start by saying, hey, immigration, I am entitled to certain immigration rights, and let me show you how I am. And so you send off paperwork, evidence, monies, and hope that they will respond and move your request along to determine whether you are correct and you deserve those rights.
Right.
Those benefits, I guess, not rights, but benefits.
Well, and to be wary of in the civil world is the default judgment, always.
Yes.
Anybody.
Give us a good layman's definition for what default judgment means, Brandon.
So, I don't know. I
do not show up to court on a day that a court issues orders. That order is a default judgment. It was made without your consent or without your input.
Right.
I'm so sorry.
I
just told you to answer, and then I was like,
yeah. Well, and I was thinking
Gunner.
Yeah. Can somebody calm her down? Anyway, so I was thinking of an example, right? Somebody sues me. I freak out. I don't know what to do. I don't go talk to a lawyer. So I ignore it. I throw it in the bin, right? After a certain period of time, they can go back to that court and ask for what's called a default judgment. And basically, the court enters a judgment against you, giving the other party basically everything they want. And you are done, right? And that's it. And it's all because you didn't show up.
Right. And it's not because you didn't have the right to show up. You chose not to show up. You always have to assert your own rights, your own requests, and give the court an idea of what you want them to do in your case.
Right.
Absolutely.
So that gets us through, I think, basically the preliminary court proceeding matters where we've been invited to court.
Yes.
Court is a party. So we get our invitations to court. We go through, first appearance, prelims, in civil world.
Initial conferences, like you said, pre-trial conferences. Most of the time in the civil world, we don't have a lot of formal court, and rather it's a lot of negotiations between the two lawyers, and then coming to court if either A, you're getting ready to let the court know of an agreement and asking the court to adopt that agreement. That would be just an uncontested hearing, right? Or a trial, and before the trial, you'd have a scheduling conference like you, determining how much time you need to exchange evidence, like you guys.
Perfect.
Did. So somewhat similar. Beats.
They look similar. I like that.
Yes.
I always get
fraternal twins. I like.
Yes, that is true. Because if you have ever met a criminal attorney who's ever had to dip their toe into civil procedure, even for a heartbeat. Oh, the pain. But, so that being said, I mean, the real finishing touches on the court process for me are motions hearing and trial.
Okay.
Right?
And what are the important features of those pieces?
So motions hearing is basically where we're asking the court for something. So in my world, most of the time, it's me saying, hey, judge, I reviewed this evidence, and I think they might have done something wrong. And now I want you to give me a remedy. And that remedy in American criminal law is suppression. Right? Which is one of my favorite things.
Absolutely.
You don't get it every day, but when you do, it's pretty sweet. And that's where you most of the time for me, it's alleging a constitutional violation, right? You search without a warrant. You talk to somebody without Miranda. So those are the issues. Those issues generally will get rid of a matter prior to trial if they're successful. And then obviously we have the trial, which, that kind of explains itself. Evidence is taken, sometimes there's a jury, sometimes there's a judge.
Yep. Law and order, not as dramatic.
Yes.
Not as cool.
Only on a really bad day. Man, if your lawyer endures a law and order day, buy them something nice. because that's a tough day. Court does
Where-
does
no.
not look like Law and Order
No, it
generally.
doesn't. No, it doesn't.
Not if everything's going well.
Correct. Okay, so now let's give people some tips and hints about two things. One, what do we do if we have to appear in front of court or in front of an administrative body in a federal agency? What are our best practices? What do you normally tell your clients? We're about to go to court, you know. I don't know. My favorite right now thing is Marvelous Mrs. Maisel. What do they say? Tits up, lady. But you can't say that to your clients. So what do you say to your clients?
And you can't say it to a judge either, unfortunately. So usually what I say to clients when I'm preparing them to appear in court is, number one, I'm going to probably do almost all of the talking, if not all of it. Right? I very, very rarely want my client saying anything, right? There's a reason that you hired me. The only time I want you talking is when the court is directing questions at you specifically. Number two, I always tell them that if at any point in time you've got a question about something, you're worried about something, you don't understand something that was said, lean over, whisper it in my ear, and if I have to, I'll stop everything right there and we'll get it figured out. Because there's no point in us proceeding forward without you knowing, right? There's a purpose for me standing there. I'm not just an advocate, I'm an educator.
Absolutely.
And those two things put together, I think, generally will put a client at ease. You know, what are the things we're most fearful about? Public speaking.
Absolutely.
And going to jail, right? And, you know, generally those are not the things that we're there for. And frankly, a good attorney should act as a shield for you so that you don't have a lot of those feelings.
Absolutely. I agree with you. For me, it's always giving people hints about first impressions. I think first impressions are really important. Every time you go into court, every time you go before an administrative body or a federal agency, everybody's watching.
Right.
Everything you do does make a difference, and so everything from your behavior to the way you're dressed. Right. One of my favorite worst stories is of an attorney who once had to represent a client who was wearing a T-shirt that said, "Tell your mom I said thanks." Judge did not appreciate that. His mom did not need thinking.
Yeah.
So things like this make bad impressions, and so it's not that you're expected to wear designer clothing, nothing like that, but you want to make first impressions by wearing clothing with little to no language on it. You don't want to create some dislike for you from anybody for any reason, right? And so things like that are important. Showing good manners, and most important, one of the things that I always struggle with, because I am very visually obvious, is faces. Do not make faces, even if you disagree with something that a judge is saying, with something that your ex-spouse is saying, with what the prosecutor's saying. Stoicism. Be a wall, hold it in, and talk to your attorney or write a note to your attorney about why you think that's wrong, but do not do anything that's going to draw the attention from the judge in a negative way, or from the administrative agent, whoever it is.
Absolutely. I can tell you from a trial attorney perspective, most of the time people only know something is wrong if your body language tells them that something is wrong. So if you can hold it in, if you cannot explode, if you can just keep your composure, most of the time nobody will even know what's gone on. And frankly, if you do explode, you're giving the other side exactly what they want, which is a reaction, and to show that you're volatile and that you're, maybe not trustworthy or something like that. So, trust in the fact that your lawyer is sitting there. They're not going to allow a lot of damage to happen to you. And so they're there thinking about what's going on. They're not reacting with their emotions, because one thing emotions can do for us are some pretty reckless things. Absolutely. Right? Measure twice, cut once. Don't fly off the handle. So
absolutely. Now, in closing, we wanted to just discuss some tips and hints about how to have a productive, financially effective, and wonderful relationship with your attorney. It is possible. You can have a really good relationship with your client and or your attorney and complete a case in a way that makes you satisfied. So, Brandon, what are some of the tips and hints that you have for clients to help them navigate through this type of process?
Ask questions. Ask your attorney questions about, what they do, how long they've been doing it. Have they been in that court before? Are they comfortable with this kind of matter? These are all legitimate questions, and they should be able to answer those for you. I always tell people when they talk to me that hiring an attorney is a lot like buying a shirt. If you don't like it on the rack, you're not going to like it when you get it home.
That's
right?
Exactly.
If you sit down and talk with an attorney and you're like, what a jerk, right? Think of what other attorneys and other prosecutors and other judges and people think of that person, right? I have always functioned with the motto that you catch more flies with honey than a stick, right? Isn't that the saying?
No.
Then
with vinegar.
Well, then with vinegar, right? Well,
but I bet that sure as hell is right.
And it's true. So,
and you're going to piss off them damn bees.
Yes, and that's true as well.
Or I guess it was flies, right? Flies.
Yeah.
Piss off the flies.
Well, if it was bees, I'll tell you.
Definitely not throw a stick at them.
No. So either way, if we're coming at this situation with a little bit more composure and we're friendly about it, a lot of times we'll actually see that we get what we want more often, because judges, just like human beings, right, generally tend to follow along with the more reasonable party, right? If you come in and you're raising hell and things are going poorly, they're probably going to keep going poorly, right? But if you can take a ding with some pride and some stoicism and show that you have what it takes to endure this process, again, it's about impressions, right? And that leaves a strong impression.
Absolutely.
So I'm sorry if I keep dragging us over,
No, that's okay. My hints for working with lawyers, and I think yours, definitely based on your practice. Mine, of course, are going to also be based on my practice. Hints for quick, effective, efficient meetings with your attorneys. Always have paperwork with you.
Oh, yeah.
Always have everything that you need. Before you go to your attorney, start building a law notebook for yourself. Write questions down that you have about your process. Do not think, I'll think about that when I get there, because you will not. Right? And you'll end up with questions unanswered, and you will feel either uncomfortable with the process, or you will feel not taken care of because you still have questions in your mind. And so write questions down. One of the great ways that we facilitate communications with our law firm is through a client portal where clients can send us messages at any time. And so if you don't have that access for you at this point, again, write questions down, have all your evidence. For cases involving hourly rate, ask your lawyer, what are things that I can help you obtain? Right? A lot of times you can save money if, instead of me having to get a document from someone for you, you get it for me, right? So a lot of times you can save time, you can save money by picking things up, by doing them yourself. And so don't be afraid to have that conversation with your lawyer. What are things that I can do that can help you save money? They'll tell you, and there will be not tons, right? Because people aren't going to be, no matter how fabulous the Google machine is, it's not going to give. It's not legal research the way we do legal research. So we're not going to steer you to do that kind of stuff. But gathering evidence that we may need, your paycheck stubs, your marriage divorce decrees, those types of things, in a lot of times, at least in my world, are very relevant. And so getting those for me saves me time, saves you money.
Right. A lot of times for me, it's medical records, because we have to go through release of information. And the fact of the matter is, you can just call the hospital and get them.
Absolutely.
Right. But in order to have them sent to me, there's got to be paperwork, and then we have to call. And so I totally jump on board with that. Yeah.
And in closing, I think that we just wanted to make sure that we were still here with you today. We want to thank you for being here and talking with us a little bit about just some legal basics. We, like Brandon said, felt that we had started off with a lot of densely packed information, how to do things, how the law is on certain things. But a lot of times the things that worry people are the little things. How do I even get started with calling lawyers?
What do I wear?
How do I figure out what lawyer to hire?
Right.
For a lot of things in the Manhattan, Kansas area, all you need to do to hire a lawyer is call 785-776-2000 because we have several areas of practice and we have excellent lawyers that can meet your needs.
And they want to talk to you and they want to help you. There's a reason that we all do this job. And it's not to sit in our office, reading all day. It's because we truly and fundamentally believe that there's help for people in this world, in this legal world that's confusing and scary. And so please come talk to us and see if there's something that we can help you with. Because at the end of the day, that's what our passions are. And
Absolutely.
Speaking of what our passions are, you're doing this immigration clinic this Saturday?
Yes.
Okay.
Saturday, February 1st, from 10 a.m. To essentially 4 p.m. There will be a morning event and an afternoon event at the Manhattan Public Library located at Juliet and Points. We are hosting a free citizenship clinic. What that means is that for people who are lawful permanent residents that want to apply to become U.S. citizens, we are going to be helping them navigate through the application for naturalization. This is in conjunction with the American Immigration Lawyers Association Citizenship Day event.
Nice.
So we're very honored, but we're very lucky because although Manhattan only has me as an immigration lawyer, just one, we have a great law firm behind us, so there's going to be other lawyers there helping us help you, and we're excited to be there for you.
Snaps for you. I'm very proud of you for spearheading that, and I'm proud of the people at our firm who are going there, helping out, devoting their time and resources. I'm proud of you for doing it. So
thank you.
It's honestly awesome.
Well, thank you. Come join us. We'll help you prepare your application for citizenship and have a coffee and a donut with us.
We'd love to see you. So thank you guys so much for joining us, and we hope that you have a great rest of your week. Happy Winning Wednesday. And
happy Winning Wednesday, and
we'll
happy birthday, Kansas.
Happy birthday, Kansas. And we'll see you next week.
Bye.
Thank you guys so much.